Thanks for tuning in for another weekly edition of Legalese. The word this week is arraignment. And I'm going to use that word. I'm also going to talk about an initial appearance because it's often served a similar purpose. In state court, we often refer to an arraignment, and in federal court, we often refer to an initial appearance. But I'm going to just call them both arraignment for purpose of this video. And an arraignment, it occurs right after you've been arrested and you're brought before the judge, typically for the first time. And at a typical arraignment, the judge is going to want to find out a few things from you. Number one, do you understand what you've been charged with? Not do you agree or disagree with the charges, but do you understand what the state or the federal government is claiming that you've done? Secondly, they're going to want to know, do you have an attorney? Or do you want the court to appoint an attorney to represent you? That's a crucial decision that you're going to make in your case. If you can't afford private counsel, then the court, if you qualify, will give you a court-appointed lawyer to represent you. The third thing the court wants to find out at an arraignment is basically a scheduling issue. When are we going to set the case for the next series of steps? If you're in state court, the most likely next step will be a preliminary hearing. And we'll talk about that in another legalese section about what actually happens at a preliminary hearing. If you're in federal court, you may actually lay out all of the dates in the case, such as motion hearing cutoff, plea cutoffs, and ultimately your trial date. Federal court often will move much quicker as far as scheduling, but an arraignment or an initial appearance is really your first opportunity to appear before the judge and perhaps have counsel with you to assist you getting through the process.